Good morning. I am John Coles, the managing broker for Reston and Fairfax. And today we're going over the Maryland Realtors residential contract of sale or sales contract for Maryland. Now, remember, this is for anywhere in the state, and you can pretty much anywhere in Maryland in the state. So, just as a reminder to our clients, this is a legally binding contract and they should seek legal advice if necessary. Also, disclaimer at the form, it's designed for the sale and purchase of improved single-family residential real estate located in Maryland only. So, can use it in Virginia, cannot use it in Delaware. It's Maryland, and again, generally single family. Um, Townhouses, condos, co-ops, um, single family houses. Yeah, I got them all. All right. We'll see as we go through. The contract is divided up into, I want to say, five sections. I'm sorry, seven sections. Uh, Section 7 talks about breach and dispute resolution. When Maryland revised their contract a couple of years ago, they divided it up into these sections to try to keep everything together. The old version was very scattered, uh, so the new version is much, much cleaner. As always, we would say put today's date at the top, whatever day you're writing the contract and sending it. Paragraph 2, the thing to remember is time is of the essence. So we're following the prescribed dates and times within the contract. So if there is a prescribed date or within a prescribed time period, we're following within that time period. And shall the failure of seller or buyer to perform any act within, again, the date or the time period shall be in default under the contract, and the non-defaulting party, upon written notice to the defaulting party, may declare the contract null and void and of no further force and effect, and all deposit monies would be returned in accordance with the deposit paragraph of the contract. So remember, one of our main jobs is to make sure that we're following within the date, within the timeframes within the contract. And that's something we need to remember to talk to our client. Paragraph 3 are the sellers, and again, we can put two sellers in here. Same for buyer, we can put two buyers in here. And the next part is where we would put the property address. Let's say the property is at 51 Magnolia Street. The next line, oops. The next line here is for the city. So let's say that's in Frederick. City and county, it's also Frederick County. And the zip code, let's say that's 12345. Paragraph 6 talks about the estate and how the property is being conveyed. So here, generally, you would put an X. Sometimes there's initials that pop up. Again, X or initials are fine. So we're putting an X here because it's fee simple. And there are some areas in Maryland where there's annual ground rent. I know Baltimore is one of those areas. Also, Baltimore and the other place is escaping me. So when we're filling this out, we need to, again, we're filling it out as the buyer agent. We need to talk to the listing agent to see if there's any ground rent, etc.
So, Jonathan,
Yes,
so is there any way that we can see that in the MLS where the property description is?
it's only as good as the listing agent putting it in.
So
So
the listing agent would put that information in there. It would be in the remarks section, right?
it might be in the remarks. It might be in the additional documents, because Maryland has a thick stack of seller disclosures. So, hopefully, it was noted in the disclosures. There's an additional addendum for ground rent. So, if there is ground rent, it would be in one of those disclosures, hopefully, or it would be in the MLS.
Okay. Thank
Uh,
you.
but yeah, Baltimore is notorious for ground rent. 7 is the purchase price. I don't know how many of us remember writing checks. So what we want to do here is just like we're writing a check. And remember, Lone Wolf is very smart about it. So let's say we're offering $500,000. On this next line, if you put the dollar amount, it will automatically put the words in the previous line for you. Let's say we're offering 510. Again, it automatically fixes the words for you. Paragraph 8 is payment terms. And if you're familiar with Virginia, it's pretty much the same concept here. So buyer either has delivered or will deliver within generally 5 days, sometimes 3, sometimes 5, whatever you and the seller negotiate. Of contract acceptance, an initial deposit in the way of generally we're putting check or wired funds. As we know, a lot of the title companies will do um, Zocam or um, usually Zocam or a wire, or there's another app that they use to transfer money. And again, just like we did with the purchase price, it's the words on that first line. And let's say we're putting $25,000. Okay. The words automatically fill out. Back in the day, and I know I date myself when I say that, sometimes you would do a second deposit. That's not as common as much anymore, but it's the same concept if you are doing a second deposit. So let's say they're giving another $25,000. It's check, wired, funds in the, oh, oops,
And
sorry.
what would the additional deposits would be? Why? Like, in what cases have you seen them?
Great question. So it's a $25,000 to be paid within 5 days. Um, we should have home inspection, maybe. Oh, if I could spell. Generally, you are not going to be doing 2 deposits. Um, again, it used to be common. It's now pretty much fallen by the wayside. So normally you're just going to be doing that first deposit, and you generally wouldn't be putting in a second deposit. Letter C is very important. All deposits will be held in escrow by, I'm going to talk about our friends at Vesta Settlements. Wow, Vesta Settlements. And this is where a lot of agents make a mistake because they don't read. They're going too quickly and they don't read. It's also in bold print here. If a deposit is not held by a Maryland licensed real estate broker, the party shall execute a separate written escrow agreement that complies with section blah, blah, blah of the Maryland law. It is a separate form that is signed by the buyer, excuse me, and the seller and the escrow agent, the settlement agent. And it's a confirmation that number one, the escrow agent, the settlement agent, has received the funds, number one. And number two, it's pushing the liability that's normally with the broker off to the settlement agent. So always, always, always remember to have that escrow agreement.
So,
Now,
so,
if
so in this, I'm sorry. In this case,
go ahead.
sorry.
Sorry.
So in this case, since Fairfax Gateway has a license in Maryland, right? You guys, I don't have to worry about that, right? Okay. Sorry about the interruption. I just want to make sure.
That's okay. Again, if the title company is holding the escrow money, you're good. On the opposite side, if you're a listing agent and if you're a listing agent and the buyer agent writes KW Fairfax Gateway, why does it keep doing that? KW Fairfax Gateway, we have to let the buyer agent know that we do not hold deposits. The Fairfax Gateway, Reston, the other offices do not have escrow accounts for deposits. So again, we would strike that out and we would change it to Vesta settlements. Again, it's just cleaner to have the title company hold the money. Letter D, purchase price, less any and all deposits will be paid in full by buyer by cash or wired funds, bank check, certified check at settlement. Letter E, again, is important. A lot of agents miss it. 99.9% of the time, you're going to check a non-interest bearing account. If it is, for some rare instance, an interest bearing account, we have to say who's getting the interest, etc. In a lot of years, I won't say how many, in Pennsylvania, the broker holds the escrow usually, and we were holding a $500,000 EMD. We had to create two extra escrow accounts because of the $250,000 limit on FDIC. And again, the buyer wanted it in an interest-bearing checking account. We probably will never run into something like that here, but again, you never know. 99% of the time, again, the title company, letter C here, is going to be holding the EMD. Number 9 is the rest of the deposit paragraph that tells us what happens. And if we scroll back up here, we have already talked about the deposit paragraph. And let's talk about it. If the deposit's held by a broker as specified in 8C, again, that bold language there, buyer authorizes and directs broker to hold the deposit instrument without negotiation or deposit until the parties have executed and accepted the contract. Upon acceptance, the initial deposit and additional deposits, if any, will be placed in escrow as provided by paragraph 8E. So notice how we're referencing the two previous paragraphs. If the seller does not execute and accept this contract, the initial deposit instrument shall be returned to buyer. The deposit shall be dispersed at settlement. In the event the contract is terminated or settlement does not occur, this is when all of the things happen. Buyer and seller agree that the deposit shall be dispersed by broker only in accordance with the release of deposit agreement executed by buyer and seller. In the event buyer and seller fail to complete the transaction in accordance with the terms, and either buyer or seller will be unable or unwilling to execute the release of deposit agreement, buyer and seller acknowledge that the broker may distribute the EMD, the deposit, in accordance with the provisions of section, give me 1 second, let me scroll down. Section 17505B of Maryland Code, blah, blah, blah. So, again, this is broker is also title agent, settlement agent, title company, whatever you want to call them. So it's important for paragraphs 8 and 9, buyer will deliver within 5 days of acceptance. C, saying who is holding the funds, and E, what kind of account it's going into. Okay. Paragraph 10 talks about settlement, the date of settlement. Again, we know generally 30-ish days, it's open to negotiation. It also says, or sooner, if agreed to in writing by the parties. I've had transactions where we have 30 days and the lender is amazing, like our partners at ACM, and they can close in 20 days, and the buyer's okay with it, and the seller's okay with it, we close early. Again, open to negotiation. Paragraph 11 is, again, one of the most important parts of the contract because it tells us exactly what is attached to the contract. And all of these separate attachments become part of this main contract. So if there's a different affiliated business disclosure, as is provisions, etc., generally the ones that you're going to see are the buyer's request for seller compensation. If it's a condo, you might have the condo resale disclosures. Again, one of the things to be very, very, very careful about is this disclosure of licensee status. If you or someone you are related to is buying the property. Now, the Virginia contract, that's the NVAR contract, that's built into it. Maryland, Pennsylvania, DC, it is not. It's an additional addendum. Generally, you're going to have disclosure of included, excluded items. If it was built before 78, you're going to have lead-based paint. Again, if there are foreign investment in Real Property Tax Act, foreign investors, you'll have that one. Usually you're going to have local city, county notices and disclosures. I know there's one for PG, there's one for Baltimore, there's additional ones for Frederick County. Up here on the second column on the right, non-resident sellers. Again, if they're not a resident seller, there's an additional addendum noting that 8 to 8.5% withholding. Normally, your again, providing the notice to buyer seller, the Maryland residential property disclosure statement. On the listing, we talked about deferred water and sewer charges. If, again, we know about those, we're including those. Superfund sites, sewage disposals. Generally, if the buyer's doing a home inspection, we're including that form. Again, here's another ground rent form, escalation. If the buyer has to sell, finance, go to settlement, or lease other real estate, we might be including that form. Seller contribution, also known as seller assist. One of the nice things in Maryland is there's a seller's home of choice addendum. And again, Virginia doesn't have this, so the Maryland one is nice. That allows the seller to have a time period that they can identify something and get it under contract and make it contingent on closing for this contract. Short sales, tenant occupied, third party, water quality, and water yield test. Again, these are all addenda or disclosure that we could add. If there's any other special conditions or provisions or addenda, again, we would check this box down here and write them on this line. This list, again, is pretty much all encompassing. Whatever we need is probably on this list. Paragraph 12 says that we may execute this contract electronically using electronic signatures. It's not 1980 anymore. When I started, we again started using, it was right when electronic signature started. And some contracts didn't allow it. Fannie and Freddie also did not allow it. That was a fun one. So now it says that we can execute using electronic signatures. Back in the day, we used to have carbon paper. There were 3 copies of the contract, and we would have to say to clients, sign here, press hard, so that their signature went through all the pieces of paper and carbon paper. You also had to be careful that you didn't tear the paper. We don't have that problem anymore. Paragraph 13 talks about the entire contract. This contract and any addenda contain the final and entire agreement between the parties, and they are bound to the terms, conditions, etc. Oral or written, and neither they nor their agent shall be bound by any terms or conditions, oral or written, not herein contained. So basically, if you're making a change, get it in writing. The parties to the contract mutually agree that it's binding upon them, their heirs, executors, administrators, personal representatives, successors, and if permitted herein, their assigns. So I don't know if I mentioned, I had my great aunt's property under contract with the power of attorney, which was her son. And there's 2 sons. And she died before settlement. I know, sad. And I'm going, uh-oh, do we have a problem with the contract? Nope, we don't. Because again, the contract does bind the heirs, executors, etc., etc. So we were all set there. Once signed, the terms of this contract can only be changed by a document executed by all parties. Remember, both parties have to agree in writing to a change. Contract shall be interpreted with the laws of Maryland, and it may be executed in counterparts, meaning, again, this happened back in the day. We really don't have that problem anymore with electronic signatures. That let's say we have a husband and wife. One is in Maryland, the other is in North Carolina. Excuse me, they can sign separate documents, and as long as they're combined, we're good. Again, we don't have that problem anymore because of electronic signatures. Paragraph 14 talks about the computation of days. The term days shall mean consecutive calendar days, including Saturdays, Sundays, holidays, whether federal, state, local, religious calendars. A day shall be measured from 12 a.m. to and including to 11:59 p.m. in the Eastern time zone. For the purpose of calculating days, the count of days shall begin on the day following the day upon which the actor notice was provided in the contract, and any addendum or addenda to this contract that was required, performed, or be made. What does that mean? Thing to remember, today is day 0. Tomorrow is day 1. So if we have 5 days to do the home inspection, and today is Wednesday, Wednesday's day 0, Thursday, Friday, Saturday, Sunday, Monday at 11:59 p.m. is our deadline. Again, be very, very careful of counting days and deadlines. It is your job, both as the buyer agent and as the listing agent. A lot of people get tripped up on counting days. And thankfully, it says it in the contract. Paragraph 15 briefly goes over seller responsibility. Seller agrees to keep existing mortgages free from default until settlement. All violation notices or requirements noted or issued by any government authority, including without limitation, any permit violation notices, or actions in any court thereof against or affecting the property at the date of settlement of this contract shall be complied by the seller and the property conveyed free thereof. So the seller needs to transfer the property free of mortgages, free of liens, free of anything that could come back to the buyer. The property is to be held at the risk of seller until legal title has passed or possession has been given to buyer. If prior to the time legal title is passed or possession has been given to buyer, whichever shall occur first, all or a substantial part of the property is destroyed or damaged without fault of the buyer, then this contract, at the option of the buyer upon written notice to seller, shall be null and void and no further effect, and the deposits will be dispersed in accordance with the deposit paragraph of this contract. So, fingers crossed, everything is fine. We go to settlement, no problem. I've had this. It is not pleasant. Property burns down a week before settlement. Yeah, welcome to my life. The buyer can say, nope, I don't want the property, and walk away. The buyer can also settle on the ashes and usually, again, it depends, get the insurance money and go from there. But again, that is a story for another day. Knock on wood, that does not happen. Paragraph 16 talks about leases. Seller may neither negotiate new leases or renew existing leases for the property, which extend beyond settlement or possession date. Notice, without the buyer's written consent. Seller warrants the property is not tenant occupied or subject to any leases unless otherwise stated in an attached tenant occupied addendum. This is a great addendum which clearly states there are leases, and uh, there are leases, and these are the details of the leases, and here are copies of the leases. Paragraph 17, non-assignability. It cannot be assigned without the written consent of buyer and seller. So again, it's binding upon the parties, and it can't be assigned to anyone else. And I always have to laugh at section 18. The headings are for convenience and reference, and do not define or limit the intent, rights, or obligations of the parties. So that is all section 1. Now we're going into section 2. Section 2 talks about the payment of the purchase price, and we start out with financing. Here we're talking again that if what kind of written commitment is the buyer getting for financing? Are they getting a conventional loan? Are they doing FHA? And notice that it allows us to check multiples. So we need to be very careful that we're checking whatever correct one the buyer is getting. Paragraph 20, thankfully, has been cleaned up because it used to be very confusing. Paragraph 20, financing application. Yes, Francia.
So I'm assuming if I'm gonna be using hard loan money or cash, I can select other and
Yep,
specify. Okay.
correct. So
Okay.
you would say other, and you would say hard money, or if you're doing cash, that would mean no financing contingency.
Okay. Okay.
Great
Thanks.
question. Yep. All right, paragraph 20. Buyer agrees to make a written application for the financing. Usually here we're putting maybe 3 days, maybe 2 days from the date of contract acceptance. If a written financing commitment is not obtained from the buyer within blank days from date of contract acceptance, this is where we're putting in our contingency period. So we might be putting in 21 days, we might be putting in 25 days. Again, it depends. Let's say we're doing 21 days. And the buyer does not get the commitment. Give me 1 second, I will come back to you. The seller, number 1, the seller at seller's election upon written notice to buyer may declare this contract null and void and of no further effect, or buyer upon written notice to seller shall include written evidence from the lender of buyer's inability to obtain financing as provided in the financing paragraph of this contract, may declare the contract null and void and of no further effect. In either case, the deposit shall be dispersed in accordance with the deposit paragraph, which we've talked about numerous times. Important part, if the buyer has complied with all of the buyer's obligations under the contract, including those with respect to applying for financing and seeking to obtain financing, then the release of deposit agreement shall provide that the deposit be returned to the buyer. All right, question.
Thank you, Jonathan.
Yeah.
So when on paragraph 20 refers to written application, right? So does that mean like the pre-approval letter, or what does that mean?
Great question. So this written approval right here, written application for the financing, that is going to the lender and making formal application with the lender.
And how
And most times, again, every lender is different. Most lenders that I've worked with want a full written application before they even issue a pre-approval letter. So um, it's
So in,
whatever the lender considers written application.
so in this case, the client that I'm working with, he got a pre-approval letter. Would that suffice these paragraph requirements here?
Did he apply for a loan?
Yes, yeah, he applied to see what he qualifies for.
Yes. Yep, that would cover it.
And I can put it in on the contract, right? When I submit the contract.
Yes, most listing agents are going to want to see a copy of the pre-approval, and you usually somewhere in the pre-approval it says something that they've applied.
Okay, thanks.
Yep. And if they didn't apply and you put 3 days in here, and let's say today is Wednesday, Wednesday's day zero, Thursday, Friday, they have till Saturday to make the written application to the lender. All right, paragraph 21, buyer responsibility. If buyer has misrepresented buyer's financial ability to consummate the purchase of the property, or it is contingent upon buyer securing written commitment for financing, and buyer fails to apply for financing within the time period specified, or fails to pursue financing diligently or in good faith, or if buyer makes any misrepresentations in any document relating to financing, or takes any action which causes buyer's disqualification for financing, buyer will be in default, and seller may elect by written notice to buyer to terminate the contract and pursue remedies set forth in the default paragraph of this contract. So what does this mean? Buyer is responsible for providing a full and accurate financial picture to a lender. If the buyer says, I make $100,000, but they really only make 70, that would be a misrepresentation. If the buyer says, I work at ABC Auto Parts, and they don't actually work there, that would be a misrepresentation. Okay. Paragraph 20. So again, we want to present an accurate picture to the lender. Otherwise, the buyer could be in default. And let's just jump back up here. Or takes or fails to take action, which causes disqualification. I've had buyers do this. I tell them, do not open up a new credit card. Do not open up a credit account at Macy's or TJ Maxx or Ethan Allen or whatever furniture store because you're buying a new sofa and bed and whatnot. Don't do that. Do it after settlement. After settlement, I don't care. Don't buy a pack of gum without consulting me. Um, because again, we don't want to change your financial picture. I had a client once that just barely qualified, and she went out and bought a new couch and financed it, and she did not qualify anymore. Paragraph 22, sale and settlement or lease of other real estate. Neither this contract nor the granting of buyer's loan referred to herein is to be conditioned on condition or any matter upon sale, settlement, or lease of other real estate, unless the contingency for the sale, settlement, or lease is contained in an addendum to this contract. Unless the contract is expressly contingent upon the sale, settlement, or lease of other real estate, buyer shall neither apply nor accept a financing loan commitment which is contingent upon a precondition to funding other real estate being sold, settled, or leased. I know that's a whole lot of words. Let's break it down. So, what this paragraph means is the purchase of, we call this property 51 Magnolia Street. 51 Magnolia Street is not contingent upon the buyer settling on something else or leasing something else. That's a whole separate transaction that has nothing to do with this. If we are making 51 Magnolia Street, this contract, contingent upon their house in Pennsylvania selling, or their house in Maryland selling, or settling, then we want to include the addendum saying that this purchase is contingent on that. Okay. Paragraph 23 talks about alternate financing. Provided buyer timely and diligently pursues the financing described in the financing paragraph, again, the one that's noted above, the financing application and commitment paragraph and buyer responsibility paragraph, buyer's election may also apply for alternative financing. If buyer at buyer's sole option obtains written commitment for financing in which the loan amount, term of note, amortization period, interest rate, down payment, or loan program differ from the financing described above in the previous paragraph, or any addenda to the contract, meaning the financing addendum, the financing application and commitment paragraph, or any addendum to the contract, shall be deemed to have been fully satisfied. Such alternative financing may not increase costs to the seller or exceed the time allowed to secure the financing commitment as provided in the financing application and commitment paragraph or any addenda to this contract. Again, a whole lot of words. So basically what that means is, yes, the buyer has to apply for the financing that they said they are going to get. They can also apply for alternative financing or alternate financing, which means it's any other type of financing that is out there as long as it satisfies the financing that's mentioned above. That is the end of section 2, and we are going to hop into section 3. Why don't we take a quick 5-minute break, and we will come back and hit section 3. Now we are starting with section 3, property condition and inspections. And you're like, oh my gosh, we're only on page 3 and there's 11. As we scroll through just briefly here, there's not a whole lot to fill out in the rest of the contract. It's a lot of notices, disclosures, etc., and initials. So we're going to have to be very careful as we go through the contract. We also want to be able to explain the contract to our clients. And this generally, I always say, happens during your buyer consultation or your listing consultation. It's up to you how you want to handle it. Section 3, inclusions excluded. Included in the purchase price are all permanently attached fixtures, including smoke detectors. Certain and other now existing items which may be considered personal property, whether installed or stored on a property, are included and identified in the disclosure of inclusions, leased items, and utilities addendum attached hereto. Remember, that's a separate addendum that lists out everything that could possibly be attached in the property. Refrigerator, dishwasher, washer, dryer, ceiling fans. Those are, again, generally the top ones. Trash disposer, garbage disposal, etc. Again, it's a separate disclosure. 25, condition of the property in possession, except as otherwise specified in this contract. Including this paragraph, the property is sold as is. Again, the property is always sold as is. At settlement, seller shall deliver possession of property vacant, clear of trash and debris, broom clean, and is sent and in substantially the same condition as of the date of contract acceptance. Buyer reserves the right to inspect the property within 5 days prior to settlement to confirm the condition of the property. I always have to laugh at the term broom clean. What's broom clean? Broom clean to me and broom clean to somebody else are two different things. My general rule of thumb with broom clean is we've gone over it with a vacuum. There's no large pieces of dirt, debris, other than usual stuff. I had an agent last week ask me about attic insulation on pull-down attic stairs. Again, I wouldn't make a big thing about it. It's insulation, it's normal. Go over with a vacuum and sweep it up. But that's just me. Paragraph 26 goes into the inspection contingency. And within the inspection contingency, buyer and seller agree buyer will be afforded the opportunity at buyer's sole cost and expense to condition buyer's purchase of the property upon inspections as to ascertain any unsatisfactory conditions. Buyer and seller acknowledge that brokers, agents, or sub-agents are not responsible for the existence or discovery of any property defects. Remember, you are not a home inspector, you are not an accountant, you are not an attorney unless you actually are. And, sorry, give me 1 second. And you are not any of those things. And be very careful when you're saying, oh, this deck is falling off. Is it? It depends. Any buyer inspection contingency must be established through an addenda to the contract. And here we're putting initials that it is attached or that the buyer has declined the inspections. Section 3 is very short. Section 4 talks about property-specific disclosures. And again, some of the wording here is kind of funny. Homeowners association and condo regime. The property is not part of a development subject to imposition of mandatory fees as defined in the Maryland Homeowners Association Act or condominium regime as defined in the Maryland Condominium Act, unless acknowledged by attached addendum. So it is a property not in an HOA or condo unless you attach the addendum. Paragraph 28, disclosure of deferred water and sewer assessments. Now, we had this discussion with the seller, but if we're the buyer agent, we're not sure. Hopefully, in Bright MLS, the listing agent has uploaded this additional addendum for us to attach to the contract. And it says a contract for the resale pursuant to the section, a contract for the resale of residential real property that is served by public water or wastewater facilities for which deferred water and sewer charges have been established by a recorded covenant or declaration, again, it would be recorded in public record, shall contain a notice disclosing information about the deferred water and sewer charges. The title company will generally find this when they're doing their title search. But if a seller is subject to the law and fails to comply, prior to settlement, buyer is entitled to rescind in writing the sales contract without penalty or liability. On rescission, buyer is entitled to the full return of any deposits made on account of the sales contract. If any deposits are held in trust by a real estate broker, the return of deposits to a buyer under the law shall comply with the Code of Maryland. Buyer's right of rescission shall terminate 5 days after the seller provides to the buyer a written notice in accordance with this act. And again, this is important, it is underlined and bolded. After settlement, seller shall be liable to buyer for the full amount of any fee or assessment not disclosed unless seller was never charged a fee or assessment to defray the cost of public water or wastewater facilities by the developer, a successor, or subsequent assigned. Remember, it is extremely important to know if there's deferred water and sewer assessments because your buyer is going to be taking them on. Last paragraph here, this law does not apply in a county which has adopted a disclosure requirement that is substantially similar to the law. So the law takes precedence. Moving along here, paragraph 29. If we have a property with a private or domestic well water supply, again, this is usually a property that's a little bit more rural. Usually you're going to have private water and private septic. Yes, Francia.
So in this case, see, the source is public, right? Public
Yes.
water. So what do you have then put the initial to or just leave it in blank?
Nope, you just leave it the way it is.
Okay, thanks.
Yep, if it's public, you leave it the way it is. It's when it's private or domestic, again, it's pretty much contained on the property. That's when we're going into paragraph 29. A contract for the sale of real property which a private or domestic water supply well is located shall include a provision requiring, as a condition of sale, that the buyer ensure the water quality testing of the well be conducted. Settlement on the contract for the sale of real property shall not occur until the buyer and seller have received and reviewed the results of the water quality testing. If a private or domestic well is on the property, buyer and seller will execute a water quality test addendum and water quality test notice. Quick note, in Maryland, everything comes with an addendum. So with our home inspection, we have an addendum, and then we have the notice of what the results are. Same thing with a well. We have an addendum saying that we're doing this inspection, and here is the notice of what happened on that test, and are we happy or not happy? Also, buyer may waive the right to have the well tested for water quality. They don't care, that's fine. So the first one here, it is attached, and again, there's going to be initials here, or the buyer waives their right and there's initials here. That's only if there is private or domestic well water. In the event you're selling a rural property, there could be agricultural assessments. And it depends on how the assessment happens on this property. So, agricultural use assessment, or as we're going to say it here, is called assessment. And it is on agricultural land. To be eligible for the assessment, the land must be actively used for agricultural purposes. The Agricultural Land Transfer Act, tax, is a tax imposed under that section of the property tax of Maryland. If the property is assessed in the agricultural use category and the buyer does not intend to use the property for agricultural purposes, the tax may become due and could be substantial. The tax is imposed on the deed itself and must be paid before the deed can be recorded. At the time of sale, seller shall notify buyer in writing that the transfer may be subject to the tax. Buyer, notice buyer, will be responsible to pay the tax unless the parties negotiate a different agreement. To avoid paying the tax, buyer must continue to use the property for agricultural purposes and comply with other requirements of the law. In bold, the property or any portion thereof may be subject to the agricultural land transfer tax as imposed by the Tax Code of Maryland by reason of the property having been assessed under the basis of agricultural use. The tax assessed as a result of this transfer shall be paid. And this is where we might be putting in buyer so that the buyer is aware of it. Or we might be putting in seller if we're asking the seller to pay the tax. Or if it's not applicable, we put NA. Okay. Or you can put dashes. Paragraph 31 talks about conservation easements. Again, if it's encumbered by a conservation easement, the contract will contain a notice concerning the easement, which is contained in an addendum. Remember, I said everything's an addendum. This paragraph does not apply to the sale of a property in an action to foreclose on a mortgage or deed of trust. If the property is encumbered by a conservation easement, again, make sure you see the conservation easement addendum. Hopefully the seller and listing agent will disclose that to us before we make an offer so we know that there is an easement. Same thing with agriculturally assessed property. While we're talking about that, let's talk about Forest Preservation and Management Program. If it is part of the Forest Conservation and Management Program, there are taxes assessed as a result, and who is it going to be paid for? Buyer, seller, or if it's not applicable, you can put NA or dashes, whatever you prefer. Paragraph 33 goes into more discussion about the Forest Conservation Act notice. If the property is a tract of land 40,000 square feet or more in size, buyers notified that unless exempted under law, and as a prerequisite to any subdivision plan or grading or sediment control permit, buyer will be required to comply with the provisions of the Maryland Forest Conservation Act. Among other things, the submission and acceptance of a forest stand delineation and forest conservation plan for the property in accordance with the laws and regulations. Unless otherwise expressly set forth in an addendum to the contract, seller represents and warns the property is not currently subject to the conservation plan management agreement or any other pending obligation binding the owner of the property under said act. Further, seller represents and warrants that no activities have been undertaken on the property as a violation of the act. So it's important to have this conversation with the client if they are part of this act. And that concludes section 4 of the MAR contract, which was property-specific disclosures. Section 5, we go into general disclosures on properties. Paragraph 34 talks about the single-family residential disclosure notice, and the buyer is advised of the right to receive a disclosure and disclaimer statement from the seller. Now in Maryland, you can disclose or disclaim. The disclosure is 3 pages, the disclaimer is 1. And it comes as one document. So if it says page 4 of 4, make sure you have all 4 pages. Sometimes it gets separated into 5 pages. Make sure that you have all 5 pages. Yes, question.
So let's say in your case, like if you have a client that is trying to buy a family home there, would you always request one or the other? Would you advise them to request one or the other?
Generally, the listing agent will provide the form in the MLS, and on the disclosure, they generally cross it out. And then on the disclaimer, they say, there are no latent defects to the property.
Okay, I'm asking because in this particular property, he don't have anything on the document area.
Okay,
So
yeah.
do you think I should request it in that?
Yes, I would reach out to that listing agent and say, please send me all of the disclosure documents for the property so that I can go over them with my buyer.
Okay, thanks.
Yeah, great question. Again, some listing agents will put all the documents in bright, others will not, which makes it a little tricky and a little annoying. Paragraph 35, ground rent. If the property is subject to ground rent and the ground rent is not timely paid, the ground rent leaseholder may bring action under the Code of Maryland, a lien, and a lien may be placed on the property. If the property is subject to ground rent, they're to provide the purchaser upon obtaining ownership of the property with certain rights and responsibilities relative to the ground rent. Again, there is a ground rent addendum, and that will be in those disclosures from hopefully the listing agent and made part of the contract. In Maryland, lead-based paint is a big part of their law. And it's a very important thing with contracts. So, paragraph 36, the first part we talk about is the federal lead-based paint laws. And as we know, if a property is built before 1978, we need the lead-based paint disclosures. And again, this is in connection with the sale of any residential real property on which a residential dwelling was constructed prior to 1978. The disclosure shall be made on the required federal disclosure of information on lead-based paint hazards form that we are familiar with. The seller fills out the top and the buyer accepts it at the bottom. Seller and any agent involved in a transaction are required to retain a copy of the lead-based paint disclosure for 3 years following the date of settlement. A seller who fails to give the lead-based paint form notice and the EPA pamphlet may be liable under the Act, Lead-Based Paint Act, for 3 times the amount of damages and may be subject to both criminal and civil penalties. So it is important to have both the lead-based paint disclosure and the EPA pamphlet. That's the blue pamphlet that says, protect your family from lead-based paint in the home. And again, the buyer is acknowledging that they read and understood the provisions of this paragraph, that the buyer has received these disclosures. Now, part B is RRP, renovation, repair, and painting of a property. And again, this is from the EPA, Environmental Protection Agency, back in 2010. If the improvements on the property were built for 78, a contractor is engaged by the seller to renovate, repair, or paint the property must be certified by the EPA where such work will disturb more than 6 square feet of paint per room for interior projects and more than 20 square feet of paint for any exterior project, including window replacement or demolition. Before and during any covered work, contractor must comply with the requirements of RRP. Now, if a seller, next paragraph, is doing this work on a rental property, it is they are required to be certified by the EPA prior to performing such covered work. No certification is required for a seller personally performing covered work on their principal residence. However, they're ultimately responsible for their family, their children while performing the work. And if they want to know more information, here is a link, and where the buyer is initialing this paragraph. I was in a discussion the other day with somebody, and if a lead-based paint disclosure is filled out, it can start at the fines and penalties can start at $11,000 per issue on the form. So that form can easily lead to a $100,000 issue. Now, paragraph C, Maryland goes further into lead poisoning and prevention program. Under the Maryland Lead Poisoning and Prevention Program, any residential dwelling constructed prior to 78 that is leased for residential purposes is required to be registered with the Maryland Department of the Environment. If the property was built before 78 and is now or has been a rental property or may become a rental property in the future, a separate Maryland lead-based paint disclosure form is attached. Detailed information regarding compliance can be obtained on this website, and the buyer is initialing it. So if it's built before 78 and it's residential, there's one more Maryland form that we need for lead-based paint. There's something I was going to say about lead-based paint. I can't remember. Paragraph 37, limited warranty. And again, this is a notice to the buyer If a warranty plan is being offered with the purchase of the property, meaning a home warranty, it may be a limited warranty. Such warranty plans do not cover structural defects and may not cover pre-existing defects. Buyers should request the real estate agent to provide buyer with any brochures which describe the plan in order to determine the extent of the coverage. Also, while we're talking about insurance, there's a property insurance brochure, an informational brochure published by the Maryland Realtors titled Property Insurance Basics, What You Should Know, is available. And again, down here is the website. I know it's long and not fun, but there it is. Flood disclosures, again, very important in Maryland. Flood insurance premiums. The property or part of the property may be located, in a floodplain or flood area and could be required by the buyer's mortgage lender as a condition of financing to get flood insurance. In addition, construction on the property could be prohibited or restricted. There's a thing called the National Flood Insurance Program, which provides the ability of flood insurance and also establishes insurance policy premiums on the risk. The NFIP, those in premiums are increasing, and in some cases can rise substantially over the premiums previously charged for insurance. So, if a buyer is buying a property and it is in a floodplain, we need to have this discussion with them. Hey, your property might be in a flood zone. Buyers should not rely on premiums paid as an indication of the premiums after they purchase the property. Again, insurance can change at any time. In considering the purchase of the property, buyers should consult one or more carriers of flood insurance for better understanding. The only requirement for purchasing flood insurance from the NFIP is that if you live in a community that participates. Again, most do. The same requirement applies to the mandatory purchase of flood insurance. And for more information, here is the FEMA website on flood insurance. Paragraph B talks about flood insurance rate maps and FEMA, the Federal Emergency Management Agency, that they are currently and systematically updating insurance rate maps, and your property may be affected. Buyers advised to contact Maryland Department of the Environment and consult a flood insurance carrier to inquire about the status of the property. And here is the link to the Maryland flood maps. Remember, when you're in Bright MLS, you can search if the property is in a floodplain. I would also go to mdfloodmaps.net and double check on the Maryland maps if it is in a floodplain. Have the buyer call their insurance company and also have a conversation with the seller if the property is in a flood zone. Almost every state has what's called a guarantee fund, that the buyer is protected by the Real Estate Guarantee Fund of the Maryland Real Estate Commission. And these are for losses in an amount not exceeding $50,000 for any claim. And as we know, when we get our Maryland license or renew our Maryland license, and if there's a claim, we all have to pay into the guarantee fund. Paragraph 41, notice to buyer concerning the Chesapeake Bay and Atlantic Coastal Bay critical area. So if the property is along the Chesapeake or the Atlantic coast, It could be subject to other disclosures and disclaimers and water issues. Buyer, and again, it's in bold, so it's important. Buyers advise that all or a portion of the property may be located in the critical area of the Chesapeake Bay and Atlantic coastal bays, and that additional zoning, land use, and resource protection regulations apply in this area. It then goes on to explain what a critical area is. And this is all land and water areas within 1,000 feet beyond the landward boundaries of the state or private wetlands, the Chesapeake Bay, the Atlantic coastal bay, and other tidal tributaries. Say that 3 times fast. The critical area also includes waters of the land under the Chesapeake Bay, the Atlantic coastal bays, and all of their tidal tributaries to the head of tide. For information as to whether the property is located in the critical area, the buyer may contact the local Department of Planning and Zoning, which maintains maps. Allegheny, Carroll, Frederick, Garrett, Montgomery, and Washington counties do not include land in the critical area. So if you're in Howard, Montgomery, Frederick, you're probably fine. Carroll, you're fine. It is the areas Calvert County, Caroline County, etc., that you're in those critical areas. Paragraph 42, we're also talking about wetlands notice. Buyers advise that the property being purchased contains waters of the United States, or if the property contains land or water regulated by the state, including but not limited to wetlands approved by the Army Corps of Engineers, and or the Maryland Department of the Environment, will be necessary before starting any work. Hold on, where did I go? There we go. Or starting any work, including construction, if the work includes the discharge, dredged, or fill of material into a regulated area, or certain other activities in that regulated area. The Corps has adopted a broad definition of the waters of the United States, which occur in the Chesapeake Bay region as well as other portions of the state. The land and waters regulated by the state include tidal wetlands, non-tidal wetlands and their buffers, and streams in their 100-year non-tidal floodplain. For information as to whether the property is located in any of these areas, buyer may contact the Baltimore District of the Corps and or the Maryland Department of the Environment. Buyer may also elect at buyer's expense to engage the services of a qualified specialist to inspect the property for the presence of the Corps or MDE regulated areas, including wetlands, prior to submitting a written offer to purchase the property. Or buyer may include it as a clause, making buyer's decision contingent upon the satisfactory of the wetlands inspection. So anytime you're dealing with water, remember there's going to be additional things that could happen on the property. Paragraph 43 talks about criminal activity and sexual offenders. We've all probably heard about Megan's Law and the registry, the sex offender registry. Maryland has one as well. Buyer acknowledges that buyer is solely responsible to inquire of such matters before signing the contract. Buyer shall have no right to cancel the contract upon criminal activity or the presence of sex offenders in the vicinity of the property. Buyer further acknowledges that no real estate licensee involved in the sale or purchase of the property has any duty or assumes any duty to ascertain criminal activity or the presence of sex offenders in vicinity of the property. It is in the buyer agency agreement. I believe it's also in the listing agreement about sex offenders, criminal activity. One of the things that I always recommend when a buyer asks me about the safety of an area, or they say, oh, how safe is the area, et cetera, I tell them, call the police department. You can also check the Megan's Law or Sex Offenders Registry and uh, get more information. Paragraph 44, military installations. This does not apply to Allegheny, Carroll, Frederick, Garrett, Howard, Montgomery, or Washington counties. Buyers advise that the property may be located near a military installation that conducts flight operations, munitions testings, or military operations and may result in high noise levels. Again, if you're in, say, PG County, Andrews Air Force Base is there, so you might have some military noise. Paragraph 45, again, there's a couple parts to paragraph 45 here, and it is about notices to the parties. In letter A, we make no representations. With respect to water quality, color, taste, or operating of a public or private water systems, location, size, or operating condition of on-site sewer disposal systems, extensions of public utilities on a property, and fees or costs for public utilities on a property, lot size and exact location of a property. Buyer can review the plat upon request to the records office. And again, buyer may verify the exact size location through a survey at buyer's expense. Existing zoning or permitted uses of the property. So let's say you want to have a home-based business or a hair salon in your basement. I always recommend having the buyer check the zoning. And again, we make no representations whether property license contractors have been used to make repairs, renovations, etc. Excuse me. Paragraph B, we are not advising the parties as to certain other issues, such as soil conditions, flood hazard areas, possible restrictions due to restrictive covenants, leases, subdivision, environmental laws, easements, and other documents, airport or aircraft noise, planned use, roads, highways, construction materials, and or hazardous materials, flame retardant plywood, radon, radium, mold spores, urea foam formaldehyde insulation, synthetic stucco, asbestos polybutylene piping, and lead-based paint. Information relating to these issues may be available from appropriate government authorities. And this is not an inspection contingency. It is a notice saying that we're not experts in any of these things. C, compensation of vendors, buyer and seller each assume full responsibility for selecting and compensating their respective vendors. And paragraph D, protection of homeowners in Foreclosure Act notice. Again, this is a unique Maryland act. Buyer and seller acknowledge that under part of the Code of Maryland. If the mortgage on a property is at least 60 days in default on the date of contract acceptance, the seller has the right to rescind the contract within 5 days after the date of contract acceptance. Any provision in this contract or other agreement that attempts or purports to waive any of the seller's rights under this section is void. So, listing agents, it's important to have the conversation with the seller of their status of a foreclosure if they are in foreclosure. Paragraph 46, homestead property tax credit notice to the buyer. If you plan to live in this home as your principal residence, you may qualify for the homestead property tax credit. The homestead property tax credit may significantly reduce the amount of property taxes you owe. And for more information about this, here is the website. And paragraph 47, property tax notice 60-day appeal. If any real property is transferred after January 1st and before the beginning of the next taxable year to a new owner, the new owner may submit a written appeal as to its value or classification on or before 60 days after the date of transfer, meaning after the date of settlement. Again, to have the property taxes reappealed. Quick example, the taxes are calculated with the property value of $600,000 and the buyer bought the property for $400,000, they can have the taxes appealed. Section 6 talks about the transfer of title and closing. Paragraph 48, again, notice it is in bold, so it's important. The notice of the buyer's right to select the settlement service provider. Always, 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 the buyer has the right to select their own title insurance company, title lawyer, settlement company, escrow company, mortgage lender, or financial institution. Buyer acknowledges that seller may not be prohibited from offering owner financing as a condition of settlement. Owner financing is exactly that, where the owner becomes the lender. In recent years, there's been notices, and you'll see it in the multi-list. Seller prefers buyer use XYZ title company. That's great, but the buyer does not have to. The buyer has the right to select their title company, etc. Paragraph 49, deed and title. Upon payment of the purchase price, a deed for the property containing the covenants of special warranty and further assurances, except if it's a personal representative of an estate, shall be executed by seller and convey property to the buyer. Title to the property, including all chattels included in the purchase price, shall be good and merchantable, free of liens, encumbrances, except as specified herein, except for use and occupancy restrictions of public record, which are generally applicable to properties in the immediate neighborhood in the subdivision in which the property is located, and public easement zones. Basically, what this is saying is the seller's providing good and marketable title, except if it is in a homeowner association, then the homeowners association also is included in this title. Buyer expressly assumes risks that restrictive covenants, zoning laws, and other recorded documents may restrict or prohibit the use of the property for the purpose intended by the buyer. In the event seller is unable to give clear and merchantable title and cannot be insured by a Maryland licensed title insurer, with buyer not paying more than the standard rate as filed with the Maryland Insurance Commissioner. Seller at seller's expense shall have the option of curing any defect as to enable the seller to give good and merchantable title. Or if a buyer is willing to accept the title without said defect being cured, paying any special premium on behalf of buyer to obtain title insurance on the property is benefit to the buyer. In the event seller elects to cure the defects, the contract, again, this is unique to Maryland, the contract shall continue to remain in full force and effect, and it automatically will extend not to exceed 14 additional days. So again, automatically extends in this situation. If the seller is unable to cure the property and title, buyer shall have the option of taking title as seller can give, or they can terminate the contract by reimbursed for the seller the cost of searching title and have incurred not to exceed a half to 1% of the purchase price. In the latter event, there shall be no further liability on either of the party. Contract becomes null and void, and all deposits shall be dispersed in accordance with the deposit paragraph. So, seller needs to give clear and marketable title. If they can't, buyer can accept what they're getting or ask the seller to fix it, and the contract automatically extends 14 days. And if the seller can't fix it, they can terminate. Paragraph 50 talks about adjustments. And again, this is for ground rent, HOA fees, rent, water shall be adjusted as of the date of settlement. Taxes, general or special, and all other public government charges or assessments against the property which are made on a periodic basis, including the Metropolitan District Sanitary Commission and the Washington Suburban Sanitary Commission, or other benefits. Assessments, liens, or encumbrances for water, sewer, drainage, paving, and other public improvements completed or commenced on or prior to the date hereof or subsequent to are adjusted and apportioned as of the date of settlement and assumed and paid by buyer, whether assessments have been levied or not as of the date of settlement. One of the, I would say, funny and interesting things is this last part. Any heating or cooking fuels remaining in supply tanks at the property shall become property of the buyer. Back in the day, we used to have to figure out, all right, so your oil tank or propane tank is 500 gallons. The seller used 3/4, or I'm sorry, there's 3/4 left. The price of propane is $3 a gallon, and now there's half the 3/4 left. How much is this? And it's a reimbursement from the buyer to the seller. Not anymore. Whatever is in there is now property of the buyer. So don't have to worry about that. Paragraph 51 talks about settlement costs. Buyer agrees to pay all settlement costs and charges, including but not limited to all the lender's fees in connection, including title exam, title insurance fees, loan insurance premiums, document recording fees, notary fees, etc. Except those incident to clearing existing encumbrance or title defects, except as a buyer's obtaining VA financing, those prohibited to be paid by a veteran obtaining VA financing, which prohibited charges shall be paid by the seller. If a buyer is a veteran obtaining VA financing, buyer broker may not charge a flat fee to buyer nor the seller pursuant to the VA regulations. Now, this changed in the last couple of years and has not made it into the contract yet. Seller is advised that should seller not be able to attend settlement as scheduled, seller may be subject to additional charges, again, for further settlement. Seller is advised to contact the title company to see if additional charges will apply. Paragraph 52, we're talking about transfer charges. And this is a very important paragraph. It used to be a separate addendum. Now it is built into the contract. And this is where we have some conversations with our buyers about transfer tax and if they are a Maryland first-time home buyer or they're not. So there are two parts to this paragraph, and I'm just going to draw a line here to make it easy. In general, if a buyer is not a first-time Maryland home buyer, payment of recordation taxes and state and local transfer taxes will be divided equally between buyer and seller unless otherwise stated here. Buyer shall be entitled to receive the benefit of any local owner occupancy reduction offered by the jurisdiction. Now, paragraph B, if they are a first-time Maryland home buyer, Maryland law provides that the amount of state transfer tax due on the sale of a property for a first-time Maryland home buyer is reduced from 0.5% to 0.25% and shall be paid entirely by the seller. Payment of recordation taxes and local transfer taxes will be divided equally between buyer and seller unless otherwise stated here. So remember, it is two different taxes, and if you're a first-time buyer, it's split. So the state transfer tax is reduced by 0.5%, a quarter of a percent, sorry, reduced by 0.25%. And the recordation taxes and local transfer taxes are divided equally. Buyer shall be entitled to receive the benefit of any local owner occupancy reduction offered by the jurisdiction. Buyer is hereby notified that to ensure receipt of the above reduction, buyer should check the box on page 10 of this contract indicating buyer is a first-time Maryland home buyer and complete the required affidavit at settlement indicating that they're a first-time home buyer. So if you're a first-time home buyer in Maryland, please, 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 please make sure that that box is checked on the very last page, and we'll show you that in a couple minutes here.
That is a big difference from Virginia, definitely.
Oh yeah, absolutely. Big difference. So
about on average, how much will a first-time home buyer save on, say, a $400,000 home?
I don't have the numbers in my head. It's about $2,000 to $3,000.
Okay.
I would say minimum $1,500 to $2,000.
So can the seller, say they have multiple offers, knowing this part of the contract, they can decide not to pick the first-time home buyer, right? Because they're gonna have to pay extra.
Yeah.
Okay.
Or on this line, payment. Hold on, let me underline it here. Payment of recordation taxes and local transfer taxes shall be divided equally between buyer and seller, unless stated here. And if you're a first-time home buyer, there's multiple offer, and you could put in here buyer to pay all transfer.
Okay, yeah.
And again, I would copy the words. Recordation and local transfer taxes.
Yeah, yeah.
Would I do that on a regular basis? No.
No, of course not.
But again, each situation is different.
Each situation is different, but it's good
Yep.
to know this particular point, whether you are the seller's agent or the buyer's agent, because that can be a game changer depending on the client's financial situation.
Yes,
And if the
absolutely.
seller is just trying to offload the house real quick and move out, they don't care whether it's a first-time home buyer or not. They just want to get rid of this thing.
Correct.
Yeah.
All right. And Francia.
Thank you.
Yeah, absolutely, Simba.
Jonathan, in my
Yes.
case, he's gonna be a first time buying Maryland, but he's not necessarily a first time home buyer because this is an investor. He's not gonna
Yes.
leave the property.
So, if they are a first-time home buyer, they're a first-time home buyer in Maryland, but they're not living there. I would double check with the title company that they probably get the exemption, but again, I would double check with the title company.
To know what to put in here, right? Like
Yes.
with the okay.
Yep.
Thank you.
Good question. So we were talking about.
Could I say something about that
Yes.
question?
Yep.
Yeah, definitely double check, because usually they treat investors differently because they're buying the home to make money. The other person is buying a home to survive, to live, to have a roof over their head is their first home. They're just trying to move from point A to point B. So, that's just my guess. The investor may not get the break that the regular first-time home buyer gets.
Correct. I would say maybe, but double check with the title company in advance.
Exactly. Yeah.
Great point. So we talked about transfer tax. Now we're going to talk about some more taxes. If they're a non-resident seller, if the property is not the seller's principal residence and the seller is a non-resident of Maryland or a non-resident entity, a withholding tax from the proceeds shall be withheld at the time of settlement, except as otherwise provided by Maryland law. Seller may request the Maryland Comptroller, to issue a certificate of full or partial exemption from the withholding requirements, providing that such request is filed not later than 21 days prior to closing. For more information, call 1-800-MD-TAXES or visit the website here. 54 talks about FIRPTA, the Foreign Investment Taxes Act, 1986. Notice that a buyer of residential real estate property located in the United States must withhold federal income taxes from the payment of the purchase price if the purchase price exceeds $300,000 and the seller is a foreign person. Unless otherwise stated in the addendum, again, there's a FIRPTA addendum. If the purchase price is in excess of 300, seller represents that seller is not a resident alien, foreign corporation, foreign partnership, foreign trust, or estate, and agrees to execute the affidavit at the time of settlement. So again, there could be substantial implications for the buyer and the seller if the seller is part of FIRPTA. Again, there's a separate addenda, and the title company will ask about FIRPTA, and the title company will ask, and again, it's an additional addendum. IRS, buyer and seller agree to cooperate with the settlement officer, providing all necessary information so that they can report to the IRS filings. To the extent permitted by law, any fees incurred as a result of such filing will be paid by the seller. It's also important to let the seller know at settlement that they will be receiving a 1099-S because they're selling a property, and they better declare it on their taxes. Paragraph 54, authorization to provide TILA respite integrated disclosures, also known as TRID, which is TILA respite integrated disclosure. Buyer and seller authorize the lender, title company, escrow agent, etc., to disclose and provide copies of the closing disclosure and other settlement statements to the real estate licensees involved in the transaction at the time the documents are provided to the buyer and seller. Again, just a notification that we can get copies of the disclosures, settlement statements, etc. Paragraph 57, broker fee. The parties irrevocably instruct the settlement officer to collect the fee or compensation and disperse same according to the terms and conditions provided in the listing agreement and or agency representation agreement, buyer agreement. Settlement shall not be a condition precedent to the payment of compensation. So we got to get paid. 58, broker liability. Brokers, their agents, subcontractors, and employees do not assume any responsibility for the condition of the property or for the performance of this contract or any all parties hereto by signing the contract. Buyer and seller acknowledge they have not relied on any representation made by brokers, agents, subagents, employees, etc. Paragraph 59, property owner title insurance. Buyers encouraged to purchase property owner title insurance at either the standard or enhanced coverage rates. Generally, the title company is going to be talking to you about, talking to the client about title insurance. If they're getting a loan, the lender's also going to want title insurance, so not too much we have to worry about here. The coverage afforded by such title insurance would be governed by the terms and conditions, and the premium for obtaining the title insurance would be determined to the extent of the coverage. For the purpose of owner's title insurance premium rate disclosures by buyer's lender, here we go, buyer's lender. Buyer and seller agree that enhanced rates, if applicable, shall be quoted by the buyer's lender. Buyer understands that a policy issued to the lender, known as a lender's policy, will not protect the buyer from losses conducted by a title defect. Nothing herein obligates the buyer to obtain an owner's title insurance coverage at the time of settlement, and that the ability of owner's title insurance coverage is subject to the underwriting condition of the title insurer. Buyer understands that the broker does not warrant the condition of the title, and buyer agrees to hold the broker harmless from any title defects. So remember, there's a lender's policy and an owner's policy. As if, in many cases, the owner gets the owner's policy, as they pay down the loan, the owner's policy protects the owner. When it's paid off, the lender's policy falls away, and only the owner's policy is there to protect the owner. Okay. Almost done here. Paragraph 60 and section 7. Section 7 goes over breach of contract and dispute resolution. Here's the default paragraph that has been mentioned a number of times. And here, buyer and seller are required and agreed to make full settlement in in accordance with the terms of the contract and acknowledge that failure to do so constitutes a breach thereof. If buyer fails to make settlement or is in default due to their failure to comply with the terms, covenants, and conditions of the contract, the initial deposit and any additional deposits, again, if they were made, may be retained by the seller as long as the release of deposit agreement is signed and executed by all parties, expressing that the deposit may be retained by the seller. In the event the parties do not agree to execute a release, subject to the deposit paragraph, buyer and seller shall have all legal and equitable remedies. Now, if the seller fails to make full settlement or is in default due to seller's failure to comply with the terms, covenants, and conditions of the contract, buyer shall be entitled to pursue rights and remedies as may be available at law or in equity, including without limitation an action for specific performance of this contract and or monetary damages. So buyer can sue the seller in order to sell the home. In the event of any litigation or dispute between buyer and seller concerning the release of the deposit, broker's sole responsibility may be met at broker's option by paying the deposit to the court in which such litigation is pending, or by paying the deposit into the court of proper jurisdiction by an action of interpleader. Buyer and seller agree that upon broker's payment of the deposit to the court, neither buyer or seller have any further right, claim, demand, or action against broker regarding release of the deposit, and buyer and seller jointly and severally indemnify and hold the broker harmless from any such rights, claims, demands, or actions. So buyer and seller can't agree. Buyer and seller are going to court. The broker, or in this case, title agent, can turn the money over to the court and let the court decide. We continue on to the next page. In the event of such a dispute, an election by broker to file an action of interpleader, buyer and seller further agree and expressly and irrevocably authorize broker to deduct from the deposit all costs incurred by broker in the filing and maintenance of such action of interpleader, but not limited to filing fees, court fees, service and processing fees, and attorney's fees, provided the amount deducted shall exceed the lesser of $500 or the amount of the deposit held by broker. Most of this again falls on the broker. All such fees and costs authorized herein may be deducted and may be deducted by the broker from the deposit prior to paying the balance of the deposit to the court. Buyer and seller further agree and declare that all fees and costs deducted shall be the exclusive property of the broker in the amount deducted by the broker is less than the total of all the costs incurred by the broker in filing and maintaining the interpleader action. Buyer and seller and severally agree to reimburse the broker for excess costs. Again, knock on wood, that does not happen. That's really not going to fall on the agents. It's going to fall on the broker, or if the title company is holding it, the title company. Paragraph 61, mediation of disputes. Paragraph 1 talks about the mediation process and what it includes. It's a process by which parties attempt to resolve a dispute or claim in the assistance of a neutral mediator. This is what I like to call, and many people like to call, realtor court. Buyer and seller agree that any dispute or claim arising out of or from this contract or the transaction which is subject to the contract shall be mediated through Maryland Realtors or its member local realtor boards and association as established by mediation rules and guidelines of Maryland Realtors. Again, Realtor Court. Parties may elect to have an attorney present. That party shall pay his or her own attorney's fees. Buyer and seller further agree that the obligation of buyer and seller to mediate, as herein provided, shall apply to all disputes or claims arising prior to, during, or within 1 year following the actual contract settlement date, or when the settlement should have occurred. Buyer and seller agree that neither party shall commence any action in court regarding a dispute or claim arising out of the contract or the transaction without first mediating the dispute or claim, unless the right to pursue such action or the ability to protect the interest shall pursue such action. Buyer or seller, we're going to jump down here. Buyer or seller may commence the action only if the initial pleading or document commencing such action accompanied by the request to stay in the proceedings pending the conclusion of the mediation. If a party initiates or commences an action in violation of this provision, the parties agree to pay all costs, expenses, including reasonable attorney's fees incurred by the other party to enforce the obligation herein. The provisions of this paragraph shall survive closing and not be deemed to have been extinguished by merger with the deed, meaning transfer of the deed. So remember, we're agreeing to go to Realtor Court within 1 year. And what I hear a lot of people say is, well, if we go to court, you'll get your fees paid. Not necessarily. So we have to be very careful when we're talking about disputes and mediation. Going down here into attorney's fees. Paragraph 62, the very last one. In any action or proceeding between buyer and seller based in whole or part upon the performance or non-performance of the terms and conditions of the contract, including but not limited to breach of the contract, negligence, misrepresentation, fraud, the prevailing party in such action or proceeding shall be entitled to receive reasonable attorney's fees from the other party as determined by the court or arbitrator. So again, reasonable attorney's fees. In any action or proceeding between buyer and seller and or between buyer and brokers and or seller in broker, resulting in broker being made a party to the proceeding, including but not limited to litigation, arbitration, complaint, and claim by the Maryland Real Estate Commission, whether the defendant, cross-defendant, third-party defendant, respondent, buyer and seller jointly and severally agree to indemnify and hold the broker harmless from all liability, cost, damages, etc. incurred by broker in such action, proceeding, providing that the action or proceeding does not result in judgment against the broker. As used in the contract, broker shall mean broker as identified on page 11 of the contract, the name sales associate on page 11 of the contract, any agent, sub-agent, salesperson in connection with the broker. The term broker shall also mean, in singular, any of the brokers and or sales associates, in singular or plural, identified. This paragraph shall apply to any and such actions or proceeding against broker, including the actions and proceeding based in whole or in part upon any alleged act or omission by brokers, including but not limited to any act of misrepresentation, fraud, non-disclosure, negligence, violation of any statutory or common law duty, or breach of fiduciary duty by broker. The provision shall survive settlement and shall not be deemed to have been extinguished by merger with the deed, meaning transfer of the deed. So, we as the brokers and agents can be brought into a lawsuit for something that has gone wrong. So please don't do anything dumb. The bottom of page 10, signed by the buyer, signed by the seller when everything is agreed on. And right here for date of contract acceptance, we're putting in the date on which all final initials and signatures have been affixed. You can have Authentisign or Lone Wolf forms and signing platform automatically put a date here. Whoever's the last person signing it or initialing it. Here is this checkbox for first-time Maryland homebuyers. So if they are first-time Maryland homebuyers, we want to check that box. And then the last page, page 11, is contact information. Again, your buyer names will pre-populate and we put in the buyer's address. Same thing with the sellers' names will pre-populate from the top of the contract. And again, let's put in the seller's mailing address and information. And then again, this bottom part is for reference only. And we're filling out the appropriate information. If I'm the listing broker, it's Keller Williams Realty Reston or Keller Williams Realty Fairfax Gateway. Again, the appropriate information. And if we are a listing agent, let's say I'm a listing agent, and let's say it's ABC Realty, we would put their information on these lines. And generally, they're going to be a buyer agent. Okay. And that is the end of the 11 pages of the Maryland Association of Realtors sales contract. And stay tuned for more forums.